Understanding how to legally void a contract is essential knowledge for anyone who enters into agreements. Whether you're dealing with a business arrangement that's no longer beneficial or facing a contract with problematic terms, knowing your legal options can save you significant time, money, and stress. A valid contract must contain specific legal elements to be enforceable. These include offer and acceptance, where one party makes an offer and the other accepts it. Both parties must be competent to enter the agreement, meaning they must have legal capacity. This requires parties to be of legal age, mentally stable, and not under the influence of substances that impair judgment. The contract must also involve consideration, which means each party must receive something of value in exchange for their promises. Finally, the purpose of the contract must be legal. No contract involving illegal activities can be enforced by law. Contracts can be either written or verbal, though certain agreements like those involving real estate or significant debt must be in writing to be enforceable. When examining contract validity, it's important to understand the difference between void and voidable contracts. A void contract has no legal effect whatsoever and is unenforceable from the beginning. It's as if the contract never existed in the eyes of the law. A contract becomes void when its terms are illegal, when a party lacks mental capacity, when one party hasn't reached the legal age of consent, when performance is impossible, or when the contract restricts a party's legal rights. For example, if you hire someone to perform an illegal act, that contract is automatically void because its objective violates the law. No court will enforce such an agreement. In contrast, a voidable contract is initially valid but can be rejected by one party on legal grounds. These contracts remain enforceable unless challenged by the affected party. A contract becomes voidable when a party is forced or threatened into signing, when one party exerts undue influence over another, when a party is a minor or mentally incompetent, when terms are violated, when parties commit mutual mistakes, or when the contract misrepresents facts. To legally void a contract, you must follow several important steps. First, review the contract thoroughly to identify valid legal grounds for voiding it. This might include fraud, misrepresentation, duress, or mistake. Next, gather evidence supporting your claim that the contract should be voided. Document any instances of misrepresentation, coercion, or other issues that make the contract unenforceable. Then, notify the other party in writing about your intention to void the contract. Clearly state your legal grounds and provide any relevant evidence. If the other party agrees, you may be able to resolve the matter through mutual agreement. However, if they dispute your claim, you might need to pursue mediation, arbitration, or litigation. When a contract is successfully voided, several legal remedies may be available. Rescission cancels the contract and returns both parties to their pre-contract positions. Restitution requires the return of any benefits received under the contract. In some cases, damages may be awarded to compensate for losses. Understanding contract law can be complex, which is why consulting with a qualified attorney is often advisable when attempting to void a contract. They can help determine whether your contract is truly void or voidable and guide you through the appropriate legal process. Remember that the time frame for voiding a contract varies by jurisdiction and contract type. Some contracts must be voided within a specific period to be legally recognized, so acting promptly is important. Knowing how to properly void a contract provides protection when agreements no longer serve their intended purpose or contain fundamental flaws. By understanding the basic elements of contracts and the legal grounds for voiding them, you can better navigate complex contractual relationships and protect your interests.